Rules and ethics in court interpretation. Everyone in the courtroom relies entirely on the interpreted version of the testimony. Nobody can hear what the person is saying. Therefore, what we say and what we are interpreting is consider the word of the witness. The person that doesn't, the limited English proficiency individual, witnesses, or whoever is there watching, should be able to hear precisely the question exactly without, addition, simplification, clarifications, or omissions. We have to interpret accurately without making things easier, or if the tone of voice of people is a little intense, we are supposed to repeat that too. We can make it prettier, nicer, or edit any of the testimony or the questions or anything that is being said. We must conserve every element of information that is contained in the original message. The interpreter oath tells when you're going to go and do an interpretation, this is what they are going to read to you. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially? Those are things that you have to keep in mind. That's very important. That is actually what gives us credibility. And I guarantee you that at some point somebody will hear you if you are not accurate and complete and impartial. And they will bring it up, in other words. So make that the pride of your profession, and be sure that you strive for that. At least, of course, sometimes we make mistakes, we may be nervous, we are not perfect, but this is what we strive for. Using the best skill and judgment in accordance to the standards prescribed by law and the rules of ethics of foreign language, for foreign language interpreting in Tennessee, and that you will follow all official guidelines established by this court for legal interpreting and translating, and discharge all of the solemn duties and obligations of legal interpretation and translation. You will say, yes, I do, and then the proceeding will start. Sometimes the judges don't do this, they just skip it, and sometimes if you work traditionally in one particular court, they may actually put this in writing and have you sign it, and then they will notarize it, and then they will have it on file, so they don't have to swear you in every time. Sometimes they will still swear you in for jury trials. Issues, responsibilities, and practices. Maintaining the same register is very important. We are not the ones who are supposed to change, make the testimonies easier, or sort of summarize what is being said. So, for example, if someone says, what did you observe the subject do subsequently? We can't just say, what did you see him do next? That is not what was said, and that's not the register that was used, so we have to keep that, maintain that register. The same, like, for example, if the person says he had a metal thing on his hand with a wooden handle, we can't just say he had a hammer on his hand. It's just not the same. We have to maintain that accuracy. The word choice is important, again, because the jurors draw conclusions regarding and not only the jurors, but the judge or whoever, attorneys, draw conclusions regarding a witness and honesty, credibility, sophistication, and intelligence based upon the word choice that we use. So words can affect the way a witness remembers things, for example. So if you interpret something like about how fast were the cars going when they hit, or when they smashed, or when they collided, or when they bumped, or when they made contact with each other, the intensity of that statement is very different. So if you just, if you need to repeat, first of all, what you're going to do is maintain whatever the person asking the question is saying. So make sure that your interpretation, your word choice, matches the word that was used on the source question or language. Obscenities, unfortunately, we find them all the time, and we are obligated to interpret them. Sometimes they are very necessary for a testimony. For example, if you have a divorce on the basis of inappropriate marital conduct, the judges will actually ask if the person is saying, oh, he calls me names, the judge will actually inquire as to what kind of words or names the person has, because it would, for one person may be offensive, or other may not necessarily be, and that has to be put on the record to make sure that it qualifies as inappropriate marital conduct. Repetition and redundancies, we are to repeat those. So we don't just, if the person says, I didn't see it, see that denotes doubt, or, confusion or nervousness. And it's very different if we just say, I didn't see it. You have to maintain that. You watch and observe him at all times. We don't just say, do you see him at all times? No, we have to repeat those words, because there may be a reason why the attorney is using that. Self-corrections and false starts, we repeat those as well. Sometimes people will start talking and say things like, so let me ask you, were you walking outside? Oh, let me take that back, or strike that, and things like that. So we repeat that as well. Embellishments, clarifications, editing, we don't do that. We have to maintain the source, the message exactly as it was transmitted. Fragmentary sentences, statements like, I went to the, and there was, it was there. You can't just say, yeah, I went there and there it was. We have to repeat that. This all comes together to show the demeanor of a person and the feelings of a person, and that's all important in testimony. Nonsensical testimony, when somebody is just like, for example, people mentally impaired, or cited witnesses, someone whose child was murdered or something like that. I'm not telling you that you're going to go there and make a fool of yourself, like crying or anything like that, but you don't just interpret straightforward, like as if nothing was happening. When the person is very emotional, for example, you have to find a little halfway there, middle of the road there, to be able to show that emotion as well. Emotion, again, that's what I was just saying. And the interpreter's emotions should not be there. You will be affected one way or another by what you're seeing, and our duty is to keep that to ourselves. You can go to the bathroom and cry out loud all you want after the fact, or talk to colleagues, be able to have a support group, someone, sometimes among colleagues, we are the only ones that we can talk, because we can't disclose certain things. We don't want to talk to our family about certain things. So we want to make sure that we have someone to talk and unload sometimes what we see, but we don't show any of our own emotions on the bench, on a witness stand. You should not cuddle people or hug people, or yeah, you can hand them a tissue if you want, but you're not to show any signs, any emotions towards that person, and that's hard to do sometimes, obviously. Hand gestures, when a person is pointing at some part of their body, for example, we don't repeat that. We only interpret words. Conservation and clarification of ambiguities, that is important to do. For example, if somebody says, did you have anything to drink in the car? Do you mean, did you have something that I could drink at some point, without water, sodas, whatever? Or do you mean, did you drink alcohol in the car? Usually that's what it refers to, the alcohol, but it is an ambiguous question, and you should clarify it sometimes. Where did the car hit you? In what part of your body, or in what part of town, or in what part of the car, for example? So those are things that sometimes you have to clarify. When you have to make any clarifications, you have to step outside of the interpreter's role. You need to inform the court when you are conversing with a witness. You don't have private conversations with them. You have to say, Your Honor, the interpreter needs to clarify a term. The interpreter needs to instruct the witness to speak in shorter sentences or anything like that, but we don't directly talk to them, because it gives the impression that we are coaching them sometimes. If the volume of speech is too low, if you don't understand a term, these are things that sometimes you can practice in front of a mirror, because sometimes it's hard to do them live in court when you haven't had much experience doing this. So practicing in front of a mirror out loud, these things will help you when these things actually come real. Um, sometimes there is a little bit of tricky when the interpreter's expertise is needed, because sometimes we have to interpret culturally bound terms and or check that requires actually the explanation of the interpreter. We only go to that extent. I mean, the attorney is the one that is responsible for making any clarifications. But if we see that that is not happening, that that message is not going anywhere, then we are allowed to say, Your Honor, the interpreter would like to clarify that culturally this thing means this, or whatever. You have to clarify, and always step to the third person. Checking unfamiliar terms, you are allowed to have a dictionary or your phone or something like that. Usually, in my experience, it's easier sometimes just to ask the witness, or to ask, like, sometimes the attorneys will say a word that I may not know. And I remember at one point somebody used the word shank, and I never heard that word before. So I just said, the interpreter would like to, would the would counsel please use give me a synonym for the word shank, because the interpreter is not familiar with the term. So then she said knife, or something like that. So then I was able to go on. So that is perfectly allowed. We are not machines, and is understandable. Using English, there are sometimes words that you just use English instead of using Spanish, just the same, or the other language, just the same as sometimes we use the Spanish word because there is not a word in English, like, when they use the word comadre, which, then you can say the interpreter would like to clarify the word comadre does not have a direct translation into English, but it means that the person is the godmother or godfather of the child, of that other person's child. Sometimes the name of meals or kinship terms, or units of measurement, things like that, are specific for, they're culturally bound, and you may need to clarify. But ultimately, like I say, the attorney is the one that can elicit the explanation of any terms like that, and just make sure that you don't become a witness, because every time you're explaining something like that, you're not interpreting. So if you have to, sometimes that puts you in the role of a witness. It is the attorney's function to make sure that they clear up any misunderstanding and follow up on questions until the message is completely understood. The only situation in which an interpreter will interrupt is when the communication breaks down and it's apparent that it's not going to be clarified unless you help them. Sometimes you get questions from the witnesses. They will say, the attorney will ask, so now were you there on that date? And the witness will turn to us, the interpreter, and say, does he mean, was I at home? You can do two things. You can just interpret exactly like that. Does he mean I was at home? Or if that continues, you can ask the judge to instruct the witness to speak directly to the attorney instead of to the interpreter. Responses to challenges. Sometimes you have somebody on the public that speaks your language and may want to jump up and correct. Usually, the court will not allow a person from the public, but sometimes the victim's advocate or someone working with one of the attorneys or something like that, or the defendants themselves or the witnesses or someone will challenge the way you translated something, you rendered something. If you are 100% sure that the way you render that interpretation was correct, just let it go, and just all you have to say is the interpreter stands by the interpretation. If you find that it was a mistake, which it can be, you just say the interpreter would like to correct the interpretation of such and such. Professional relationships, be careful, because we will become familiar and comfortable and friends with attorneys sometimes, and we don't want to give the impression that we are the defense interpreters. We are impartial. We are in the middle. We don't take sides. So even though sometimes in a regular court day we might actually be, having, informal conversations and shaking hands or joking or whatever with attorneys. Make sure you don't do that when there is a jury trial, when the jury is actually watching you. And obstrusiveness, we strive, like we say, the interpreter is invisible. We want to be invisible. We don't want to, we unintentionally attract attention because people sometimes are fascinated watching us. So we want to make sure that we are not, showing off. We're not there to show off or to show our skills or to show how wonderful we are. We are there only to make sure that the parties that don't speak English can understand everything, and vice versa. But we don't want to create, direct any attention, unnecessary attention to us. Um, that's very important for us to remain, sort of invisible and just be able to be that conduit needed there, but not a showman in a way. Cultural expertise, we talked about that. Interpreter fatigue. It is recommended that any proceedings that are going to be more than 2, 3, 4 hours, that we work in pairs. There is something documented, scientifically documented, called interpreter fatigue, which means it's not just, oh, I'm tired. It means that it's been proven that interpreters lose accuracy after about 20 or 30 minutes of interpretation. We all are different. That is not something that I will take it to the T like that. I mean, sometimes you might end up doing a whole long hearing on your own and be perfectly accurate. But if you are called to do a jury trial, something is going to be 2, 3 days long. Make sure you don't do that by yourself. Familiarization with the case. If you are contacted to do, for example, a trial or a hearing of any sort, make sure that you ask. If it's hard sometimes to get this information from the courts, but or the attorneys, but ask them. You don't lose anything. At the very minimum, you want to ask them what is the subject matter of the hearing or the trial, because then if it is okay, insurance claim, or if it is a landlord situation, or if it is a divorce issue, or if it is a murder case, or if it is a assault, or whatever it is, you can go and research terminology based on that. If they have anything to give you, that's wonderful. Sometimes they might have actually the main, the initial filings of the case, or the initial complaint, or things like that you can read. A list of witnesses, things like that will help you in a trial. Make sure that you can hear properly. If you can't hear, you can interpret. So the court has to make sure that we are able to hear, whether it's positioning us in a particular place, or ensuring that the mics are working, or telling people to speak out loud. Pre-testimony interviews, when you go, it's sometimes very useful to go meet the witness outside. Make sure you are with somebody else. Don't do it by yourself, just to not create any issues, or conflict of interest or anything like that. Just go with the DA, or with somebody. If it is a witness, then ask the DA to come with you, or the victim's advocate, and just say, hi, my name is so and so. I'm going to be your interpreter today. Where are you from? I'm from whatever. Do you understand my Spanish? Do you feel comfortable? You can take their address. And sometimes, for example, they'll say addresses and they pronounce badly in English, and you can't figure out what they're saying when you're on the stand. Things like that. You can, just make sure that you can communicate with them and ask them to speak in shorter sentences, not to ramble. You can explain to them that you're going to speak in first person, and that they need to speak directly to the attorney, and not turn around to you and ask you a question. All of those things will give you a better, smoother interaction on when it's actually happening, when the real hearing is happening. Technical terminology, back to the familiarization with the case. It's important to make sure that you are capable of doing this. If they're calling you to do a, let's say, medical malpractice case, you will definitely need to review vocabulary and make sure that you know what they're going to be talking about, because they're going to be talking about specific things in medicine, or things like that, or drugs, or whatever it is. Or if it is something civil that may have to do with technology or whatever it is, you make sure that if you don't feel able or comfortable doing that, you should recuse yourself from it. Jury instructions are probably the most challenging things that we do. They are very fast. They are, the good news about it is that they're pretty much all the same. So once you have one, you can sort of copy from those so you can prepare yourself. Even if you do one in a trial, then you don't do one for months sometimes, and you have to practice again and prepare again when you're going to have another trial. And those are basically the code that was written in the law books, and it's the judge instructing the jurors of how they have to decide the case, and it has all the specifics of the law, and they read that very fast, and they read the entire thing because they're required by law. And I will share some of those examples with you as well, and there are some videos included here as well. Disqualification, again, I mean, the court can decide that you're not qualified to serve on that trial or in that case, and you should be able to disqualify yourself as well if if you find that you are not comfortable doing that particular subject matter. Continuing education, we have certain amount of continuing education that we have to do. It is our duty to do that, and our duty to the profession, technically, to continue improving our skills and our education. Idiomatic expressions are something that are very, very hard to deal with in court because they are not necessarily always translatable. So you will see, well, there are, one thing that you want to know, first of all, is make sure that you know what they mean. You may not know specifically the translation, or you may not have an equivalent, or not know the equivalent in your language, but if you know the meaning of the idiomatic expression, at least you can explain it, and that is okay. In other words, even in a test, if you come upon one of them in a test and you don't know the equivalent in your language, say the explanation, explain it, say, explain what it is, or like in the interpretation, just sort of do that explanation instead of supposed to skipping it. But it is okay to explain the meaning to a witness, for example, or to someone that you're interpreting for if you don't know the exact translation, because sometimes it may be not something that exists on their in their particular language. So there are a few examples here, have hundreds of these. And I've listed just some here, and there are some resources also that I have given you on the other sheet, on the resources sheet that I share with you. So what is ethics? Ethics is the branch of philosophy that defines what is good for an individual or a society, or what is bad for that matter. So Rule 41 is the one that has our code of ethics, and that guides when we swear, to interpret according by the law, the standards prescribed by law. This is what we are talking about. Rule 41 is a law, is what rules how we become interpreters, if we were supposed to do or not. And if we don't do this, we can actually, if somebody brings a complaint against us, we can be, lose our license for that matter. So Canon 1, you can go and read it in detail again, but I'm just going to go over briefly here just to make sure that you understand it quickly. But be sure to read this in detail, because the rule itself has explanations and details on it that are much more extensive than this. Canon 1 talks about accuracy and completeness. Again, it is our duty to make sure that the message that we are rendering is complete, that we are not just summarizing or sort of guessing or hinting or giving just a kind of half good interpretation. We have to make sure that we are able to do that accurately and complete. Representation of qualifications, it is against our code of ethics to say that we are certified when we are not. Sometimes people think that because they did this workshop and they receive a certificate, a piece of paper that says that you completed the workshop, they think that they're certified, or they will state that they're certified. That is inaccurate, and you can be, there can be a complaint against you, and you can get in trouble for doing that. You are not supposed to represent your qualifications. Impartiality and avoidance of conflict of interest. This is very important that if you have any idea that you may have any kind of conflict of interest, that you at least disclose it. That's the most important thing. Disclose it, then you'll be clear. And the judge will know that you said that. Like, for example, we talked about some examples, like if you were called to do a deposition, for example, in a civil case, and the attorney paid you. And then all of a sudden you come to court and you find out that a trial that you're about to interpret for, you were the person that did the deposition there, and now you're being paid by AOC here, but you were paid by one of the parties previously at a deposition. So the only thing you have to do is say, Your Honor, the interpreter needs to disclose for the record that she or he was the interpreter at the deposition with the one of the parties and was paid by one of the parties. The judge may then say, do you think that you can be impartial and interpret impartially from here on? And you will say yes, probably, because it has nothing to do. That's, it's our duty to impartiality and avoidance of conflict of interest is there in accuracy. So it doesn't really matter if you are really a good interpreter and you're bound, really guided by the rule of the code of ethics, then you shouldn't feel that it doesn't matter. I mean, there has to be, you to be able to pull it together and just interpret what is being said and not interpret to the best interest of one of the parties. But at least you have to disclose that. Professional demeanor, make sure you conduct yourself professionally. Some people maybe, like I said, they like the camera a little too much and may want to be showing off a little too much. We are not there to show our skills or our, suits for that matter. We are there just to work for the people that need us to interpret for them and to assist the courts. And we are, we need to dress appropriately to go to court, and we need to act appropriately when we are in court. Canon 5, confidentiality. We are not allowed to report anything said in any of our interactions. There is something called attorney-client confidentiality, and we are part of that when we are interpreting for them. We are obligated to keep that confidentiality. And sometimes if you work with co-defendants, with 2 or 3 people charged on the same crime, you may be helping all 3, 4 of those co-defendants with their attorneys. And you have to be absolutely sure that you are not going to repeat anything that you heard in any of those interactions to the others. You limit yourself to interpret, and that is as far as you go. Canon 6, restriction of public comment. We keep our stuff to ourselves. That's why I said if you want to, if you need to vent and need to release some, stress sometimes because you've been in a complicated situation or something like that, interpretation, find yourself a colleague, a fellow interpreter that you trust, that you can have these conversations and talk about, whatever you need to, but make sure you're not going out on Facebook or any social media or simply talking with the public in general about any particular case, whether the information is privileged or not, whether it's in attorney-client confidential conversation or not. We should just not. That's part of conducting ourselves professionally as well. The scope of practice, again, we limit ourselves to interpreting and translating. We don't give legal advice or express opinions. I mean, a lot of times attorneys will say, what do you think? What do you think he's lying or not? That's not our job. Our job is to interpret, so limit yourself to that and you'll be out of trouble. Canon 8, assessing impediments to performance. Again, if the volume is too low, if there is too much noise, if somebody, whatever it is, you don't understand the person, whatever it is, don't just wing it. You need to report that. You need to make sure that you are capable and able to do your job. And if not, they, they need to rethink what's happening. In other words, if you're sometimes you might in this era now with Zoom, sometimes you're doing Zoom hearings and it is impossible for you to interpret because you can't hear the person. The internet keeps cutting off or something like that. Don't just keep going. Make sure that you voice your concerns and you let the court know if they decide to go over, knowing that you're not understanding and the people are not understanding you, then it's their job. But I mean, at least you need to disclose that as well. Canon 9, misconduct. An interpreter shall not commit a criminal act that reflects adversely on the interpreter's honesty, trustworthiness, fitness as an interpreter in other aspect, another respect. Likewise, the interpreter should not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Obviously, any crimes or anything. That's why they do a background check on us before we become registered. So anytime that if there is any crime committed or anything like that, you should report it. If not, they might find out at some point, but it is a reason to disqualify an interpreter for sure. And Canon 10 is the duty to report ethical violations. Sometimes we are in situations where they are a little tricky and we see that something is being done. This is not something that happens every day either, but let's say that you are in a situation where you feel that an attorney is intimidating a client or is telling them to commit a crime or do something like that. In those cases, those are ethical violations that you may need to report to somebody else. So I would say be careful with who you speak with. And there are many different situations in that matters. You will have to sort of decide who are you going to talk to. Or if you, for example, observe that, you may be observing another interpreter giving advice to somebody. That is an ethical violation. And if I see that, I would go probably if they're doing that to a witness of the state, I will go to the district attorney and say that I just saw that. Or, if I see an attorney, again, let's say that somebody is being violent or aggressive or whatever, anything that is extreme, there's nothing that's going to happen that will require this typically, but if you see something like that, you need to report anything on that matter. Canon 11, professional development is our obligation to continue improving our skills, like we talked before. Not just for the continuing education units that we have to present, but simply because we are in a field where we are in a profession that is constantly changing, or we never finish educating ourselves. We are always studying, and we are always learning more. And there won't be a day when you are the perfect interpreter and you know everything already. Canon 12, we are required to do pro bono public service work. Nobody's actually checking that or making you show proof or anything like that, but it is in our code of ethics that we are supposed to do some amount of pro bono public service as well. You can do that, volunteering with someone, or sometimes simply comes from interpreting for free in some situations where, whatever, it just some situation presents and it's part of your, duty just to kind of help them in that kind of pro bono work. Like Legal Aid Society, for example, sometimes has legal clinics that they do, and that is something that you can join them and get your pro bono work. In the book, you'll also find some exercises, and just going to go briefly over this, but like, for example, what if a witness is asked, they ask the witness to spell the name and he spells it wrong? What do? You just spell it exactly like the person did it wrong, and then the attorney can clarify. If the witness says something like year, you just say what the witness say. You don't correct it. If the witness keeps saying, tell him, tell her, I talked about this already, you can either repeat what the person says or tell the judge to instruct the witness to speak directly to the if the witness goes on and on, it doesn't give you a chance to interpret, and sort of develop a little bit of a your own game there. You can sometimes raise your hand and you can talk about that on the pre-session sometimes. Tell them if I raise my hand, just let me interpret first because you're going too long. But also, if not, you can just ask the judge to ask the witness to let the interpreter interpret. If they use hand gestures as part of an answer, just interpret the words and not the hand. What if I don't understand an attorney question? We talked about that. What if a defendant keeps talking to me while I'm trying to interpret? Same thing. Your Honor, may the court instruct the witness to not speak directly to the interpreter. If during an arraignment process, for example, the defendant approaches me and says, "What should I do?" We are not allowed to say anything like that. We can direct it to the attorney, or we can just say, "You can ask the judge. I can give you advice." If the person says, "Should I plead guilty?" Sometimes the defendant will come to you and even while you are interpreting, you simply repeat. If you are right in the middle of an interpretation and the person says that to you, you repeat what the person said. The judge will guide them, or you can refer to the attorney, talk to the attorney. If the attorney told the client if the attorney tells the client how he or she should testify, and tells them that, for example, tells them to lie, they're basically telling the witness to lie. That is an unethical situation, and you should probably refer to either the judge, or if you don't go, if that's happening with a defense attorney, you're not going to go to the district attorney and tell them that. You want to go to an impartial party. You can tell that to a court officer and see if you trust any of them, or you can just go straight to the judge and tell the judge what you just witnessed. What if I know the information the attorney is seeking and it doesn't know it? We are not to tell that we are only interpreting what the person is saying. Even like I said before, you may know the information because you were in other meetings with other people, with other defendants, and you're not allowed to repeat that. If you hear a mistake from another interpreter, usually if you're working with a partner, sometimes that may happen, and you can just say, stand up and say, "Your Honor, the interpreters need to confer with each other for a second." Go to the other interpreter, tell them quietly what the mistake was, and then the interpreter can decide if he considers that it was a mistake. He will correct it on the record, or you can. Or the interpreter might consider that he stands by the interpretation and just leave it as it is, and just say that the interpreter stands